Good morning, everyone. Thank you so much for joining the Surrey Board of Trade. I am Rona Doria, Events and Sponsorship Coordinator of Surrey Board of Trade. I want to welcome you to today's Digital Impact Learning Lab, Bill 41, Workers' Compensation Amendment Act, and what employers need to know. I wanted to remind you that if you have any questions during this session, please put your questions or comments in the chat function and we will get to them as soon as we can. If we are unable to answer your questions, we will get back to you after the session is over. I acknowledge that we are in the traditional territory of the Coast Salish people, specifically the Kwantlen, Katzie, Quiquetlam, Kakite, Semiahmoo, and Tuasin First Nations. As well, I acknowledge the Inuit and Métis Nations peoples who live and work on these territories. The Surrey Board of Trade is Surrey City Building Business Organization, where we support business and bring business into the city. We are here to advocate for you, to instigate change at different levels of government, and to be your concierge of connections. Check our diversified portfolio at businessandsurrey.com. I am now pleased to introduce your facilitators this morning from KSW Lawyers. Chris Drinovs, firm partner, employment and disability lawyer, and Alejandra Hineo, employment and WCB lawyer. Ali, over to you.
Thank you so much. I really appreciate you guys having us this morning. This is an area of the law that Chris and I are very passionate about. And the changes with Bill 41 are very significant and are going to have lots of importance for employees and employers. So we're happy to share this information with all of you. I will let Chris introduce the team first.
Great, thanks, Ali. Welcome, everyone, and thank you for taking some time out of your schedules to attend this morning. Ali and I are both from KSW Lawyers. We're proud to be the largest full-service law firm in Surrey. I'm the head of the Employment and Labor Group, and I've been involved with the Surrey Board of Trade and various other chambers of commerce for many years now, and I certainly value and appreciate what the Board of Trade can do for businesses and the advocacy work that it does with government for businesses. Our employment and labor team has 7 lawyers that are all dedicated to various aspects of employment and labor law. Ali, for example, has a specialty in WorkSafe BC, workers' compensation matters. We also handle labor and union matters, which has become really important with changes to the labor code and it being easier to unionize in British Columbia. We do wrongful dismissal, employment standards, and human rights cases. And we also do non-litigation stuff like helping businesses with employment contracts, policies, and other employment-related planning. So the focus of today's presentation, it's going to be the Bill 41, which is the Workers' Compensation Amendment Act. And it was introduced to the BC legislature by Labour Minister Harry Bains in October of last year, and it was passed into law at the end of November last year. So there's a whole bunch of changes that come with the bill, and we'll be going over them today. But essentially, it introduces various new duties and obligations that apply to employers in regards to WorkSafe BC claims of their workers. And it adds new financial aspects to the payment of benefits for workers that we'll get into shortly. The feedback that we received from various business advocacy groups, such as the Employers Forum, which we're a part of, which represents businesses regarding WorkSafe BC changes, is that there was very little consultation with the business community about these changes before the bill went to Parliament. So there wasn't a lot of chance for businesses to provide feedback, and there wasn't a ton of consultation before this bill came into law. And so I think the history leading up to the bill is quite important because it's the latest in a number of very significant changes that have been made to the workers' compensation system in BC by the current government to make it more what they call worker-centric. So basically since 2018, the government has commissioned 5 separate reports to review various aspects of the workers' compensation system. One of the biggest of those reports was one by Jeff Parr, who's currently the chair of WorkSafe BC, and another one was written by Janet Patterson, a retired labor lawyer, called the Patterson Report. So that Jeff Parr report came out in 2020, and the first kind of wave of changes we saw to the Act came in Bill 23 in July of 2020. So with Bill 23, there were a whole bunch of changes made to the rights of workers making compensation claims. The maximum wage rate was increased. There was more generous consideration for pensions for workers that are disabled with permanent disabilities. There was increased healthcare entitlement for workers, and there was better considerations given to the retirement date for workers getting benefits. So all of that increased the costs for employers. And it was essentially in 2021, as a result of those changes, there's about $3 billion in claims costs, which was the highest ever in the history of the Compensation Act. And if you compare that with the premiums that were collected from employers, 1.86 billion, there's this massive shortfall in this system that's supposed to be funded entirely by employers' premiums. So the shortfall was only made up by WorkSafe BC's investments. But if it wasn't for the returns on those investments, there's likely going to be an underfunding in the workers' compensation system with these changes. And so that's obviously something to be concerned about, and something that is going to result in likely increases in the base rates for employer premiums over the next couple of years to fund the changes that occurred in 2020, and then the changes that are going to be happening with Bill 41. As I mentioned, there was this Patterson report that came out in 2019, and it's a 500-page report with 102 recommendations for changes to the compensation system, all of them favoring workers. You can check it out online. It's very extensive. So basically, the projections are that these changes in Bill 41 are going to cost employers about $100 million a year, and it could result in premium increases of between 3 to 5% to fund these costs. So that's the context that we're seeing these new amendments coming in. I think because of these costs, employers are wise to pay more attention to workers' compensation claims to understand the system better and understand what they can do to try to mitigate some of these serious expenses coming their way. So with that, I'm going to turn it over to Ali to introduce some of the key changes brought in by Bill 41.
Thank you, Chris. So let's just get started with the Fair Practices Office change and the Fair Practices Office Commissioner. So just some background on the Fair Practices Office. This is a body that WorkSafe provides to workers so that they can go and raise any concerns that they have with respect to delays from the board or any other administrative complaints that they have with respect to how the board is operating their claim. The Fair Practices Office does not represent workers, and they don't assess the merits of the decisions that are being evaluated. However, if there is unfairness, this is where workers go to raise some of these concerns, and this is where employers can also go to raise concerns. Bill 41 is now introducing a Fair Practices Commissioner. So this person is going to be responsible to investigate the complaints by employers and also workers. And this is someone who is dependent from WorkSafe. That being said, the Fair Practices Office will continue to be the first level of independent review for complaints. And to access a review by the commissioner, the complaint must first have been registered by the Fair Practices Office. And the benefit of having this person is that these concerns can be addressed at a more systemic level. So if there's a pattern of injustice or disorganization, this is something that can be escalated to WorkSafe so that can be better addressed for all of the workers, because that's not currently in place. WorkSafe BC has hired the new Fair Practices Commissioner, Alan Seckel, and Mr. Seckel has had a career in private practice, public service, and the nonprofit sector. And the commencement of this change is May 1st of this year. So that is something that I think it's going to impact the efficiency for both employees and employers on how WorkSafe runs their claims. Another change that we're seeing is the addition of workers or employers having the ability to request an independent health professional during their WCAP proceedings. This will allow workers to seek independent medical examinations to comment on conditions that are being debated under their claim. Employers and employees currently are not able to request that WorkSafe provide independent health professionals for appeals at WCAT. However, they can do so out of their own initiative and cost, and then they can make an application to WCAT so that that cost is reimbursed. A benefit of this is that a challenge that we often see is that employees have difficulty finding a medical practitioner who is familiar with WorkSafe policy and who is willing to provide an opinion on their medical condition or the issue that's under the review. So this definitely makes it a lot easier for everybody to access that opinion. I should note that employees can request WorkSafe provide an independent health professional to streamline this process. So that makes it a lot more efficient for everybody. Another change that we are seeing is that WorkSafe has increased the compensation that WorkSafe clients and can receive for non-traumatic hearing loss. So this has increased the maximum compensation for the hearing loss, which is currently capped at 15% of total disability when there is no loss of earnings. So the table that I have attached at the PowerPoint right now shows what the percentage of disability people can receive, obviously dependent on the level of impairment. Now we are moving on to payment of interest. And in this section, WorkSafe has now allowed interest to be paid on any amount of compensation that is determined to be payable following a review under Part 6 or an appeal under Section 288. And this would remain, and this is effective for periods of at least 180 days after the effective date. Interest is payable under subsection 2, which must be calculated in accordance with the policies of the Board of Directors. And despite this section, if interest is payable on an amount of compensation under section 312, the interest will not be payable to the same amount. The interest will be effective April 3rd of this year, and there is no need for workers to apply for this interest. The details of the payment will be outlined in the corresponding decision from the review division or the workers' compensation appeal tribunal. And the interest will also be calculated and paid automatically once the benefits owed to the worker are paid. The interest amount will be paid according to the existing payment delivery method by check or via direct deposit, whichever the worker has subscribed to with WorkSafe. One more change that has been implemented with Bill 41 is that it is restoring the workers' compensation's benefits to the full rate of the annual percentage changes in the Canadian Consumer Price Index. So WorkSafe will have the discretion to approve annual indexation above the 4% if the percentage exceeds that amount. And just some background, the cost of living adjustment is a percentage that WorkSafe adds to the compensation that is being paid to workers so that they reflect, obviously, inflation and other market values. And since 2002, the cost of living increases for benefits have been indexed to the rate of the consumer price index minus 1 percentage point to a maximum of 4%. And this obviously limited the cost of living increases, and it has been unfair to workers. And as you can imagine, inflation is a very serious matter right now, and the cost of living is very high in the province. So we do think that this is a positive change to reflect the market realities today. And Section 73 prevents an employer directly or indirectly from preventing an employer to apply for compensation under the Workers' Compensation Act or to receive compensation under the worker compensation provisions. And this regulation, I think it's really significant because employers can be getting backlash from WorkSafe when they prevent an employee from filing an injury claim or from receiving compensation. Some of the issues that have been raised in the past is employers offering to pay an employee so that they don't file a WorkSafe claim, or offering to come up with some kind of alternate arrangement with the worker so that they don't go to WorkSafe. This is strictly prohibited, and this regulation makes that a lot more clear now. Now, in the table that I have up on the screen, you can see the effective dates for a lot of the changes that I have mentioned. The ones that are going to be, significant for employers are going to be the duty to cooperate and the duty to maintain employment, which Chris is going to discuss. And I'll pass it over to you.
Thanks, Ali. So, yeah, you can see that a number of these changes are beneficial for workers, particularly the increase in the cost of living lift that a worker will get if they're being paid compensation benefits, and then the interest. So if a worker is successful in appealing a decision and there's some sort of a retroactive award payable to the worker as a result of that appeal, WorkSafe BC is now going to pay interest on that amount because the worker didn't, get those funds when they should have. So that's a new change, and again, great for the worker, but increasing the overall cost of the system, which is ultimately funded by employers. So this commencement date table is important because you can see that a number of the changes, including the claim suppression provisions, which make it a penalty, make it illegal to try to prevent a worker from making a claim, that came in immediately, as did the changes to the hearing loss disability and the cost of living increases. Some other changes came in April and May. So the payment of interest is now effective, as is the access to an independent healthcare professional for workers and employers that are involved in an appeal with WCAT, the Workers' Compensation Appeal Tribunal. And then the Fair Practices Commissioner has been hired, as Ali said, and that office is now set up to kind of monitor major issues coming up with the workers' compensation system and having some power to deal with, systemic issues that come up. If the Fair Practices Office is reporting, we're getting this complaint 20 or 50 times, you guys need to fix this, so the commissioner will then get involved. So hopefully that'll be a plus for both workers and employers to make the system more efficient for everybody. So the two items that have not yet come into effect are probably the most significant in my view, as far as new changes that employers need to know about. The first of those is the introduction of a duty to cooperate. So like I said, this is not yet in effect. So existing claims, this doesn't apply. Claims that are happening now, it doesn't apply. It's going to come into force by regulation sometime in the future. So what we're hearing from our sources is that WorkSafe BC is currently doing consultation with stakeholders, and their policy department is developing policies that are going to help provide guidance for these two duties that are coming out. So likely they're going to come into effect sometime in 2024. So the duty to cooperate, what is it? Basically, it's a reciprocal duty that applies to the employer and the worker. And there's kind of three parts to it. There's a communications piece where if a worker is injured and goes off work, then the worker and the employer need to contact each other as soon as practicable to get talking about coming back to work. Second part of it is the employer, and if they request the worker to assist, the worker has to identify suitable work for the worker that, if possible, restores their wages for them to come back to work. And then thirdly, the board has to be kept informed, WorkSafe BC has to be kept informed about what's going on, and both worker and employer have to talk to WorkSafe and answer any questions they have about what's going on with this process. So I think the first thing to bear in mind is this duty is only going to be triggered when there's a work-related injury, and WorkSafe BC receives a claim for compensation. The employer gives a report of the injury, the worker gives a report, and WorkSafe BC deems that this is indeed a work injury that occurred in the course of the worker's employment. So that's the first requirement. Secondly, the worker has to be disabled from earning their full wages. So they have to have some sort of a work-related injury where they have been unable to, work full-time, or they've been put off work altogether because of the injury. If those two things don't happen, then this duty to cooperate doesn't come into effect. And I think that's a reason to pay attention to a WorkSafe BC claim or application at the very beginning. Because if you don't believe it's a valid claim, if you think that, this is your employee hurt themselves over the weekend when they were moving, or if you think that this is a pre-existing back injury that has nothing to do with your workplace, it's important to intervene at the beginning stages so that you could potentially head it off at the pass, have the claim not accepted, and therefore not be subject to these various duties that I'm going to talk about. So the first piece of the duty to cooperate is that you have to contact your worker. And this might seem a bit counterintuitive because you generally think, well, my employee is on WorkSafe, they're going to deal with their case manager, they're going to get rehab done, and then I'll hear from them in a few months once they've done that. Or similarly, a worker might think, I'm on a WorkSafe claim now, I don't need to talk to my supervisor, I'm just going to deal with my physiotherapist, and then once I get cleared to come back, I'll start talking to my employer again. That's not the case. That's not going to be the case anymore with this new duty to cooperate. Both parties have to get in touch immediately and start talking about what does the employer have to offer the worker as far as suitable work and coming back to work. And I think this could be a good thing because if worker disappears on a compensation claim, it can be very frustrating not knowing what their status is. You could have an opportunity for them to come back. You could have some suitable work for them to do, but you can't get a hold of them, right? So it's a missed opportunity, and the claim may be prolonged because of a lack of communication. Now there's actually a statutory legal duty for both parties to get in touch and start talking. So I think that's a good thing. The phrasing used is as soon as practicable, and that's been interpreted in other contexts to mean basically as soon as feasible, as soon as reasonably possible when you consider all the various circumstances at play. So, if the worker's in hospital getting a surgery, you don't have to be calling them up or at the hospital wanting to talk to them. But, assuming that they're able to communicate, their initial injury's been dealt with, there's no immediate need for medical care, that's the time when you guys have to start getting in touch with each other. The one exception to this in the new changes is that if the communication itself is going to imperil or delay the worker's recovery. So you could have situations where there's a bullying situation, there's a serious mental health situation that originates from someone at the workplace, or perhaps the very person that the worker would be communicating with. So in those scenarios, there's this exception that the communication doesn't have to occur if it's going to make the worker's condition worse. So as employers, you want to assess the situation in each case and make a determination. Is calling my worker going to make their condition worse? In most cases, it won't. But if you think it might, exercise some caution, as there may be an exception there. The second part of the duty is, what do you have to talk about? So the goal of this communication is to identify suitable work that restores the worker to their pre-injury earnings. The point of this thing is to get the person back in the saddle, back into the workplace, and out of the workers' compensation system. So, and it starts with the employer, right? Because obviously the employer knows, the business, they know what positions are available, but it's also an obligation of the worker, right? To be evaluating themselves and to know what they can and can't do, what their doctors told them, all that kind of stuff. So if the employer asks, the worker has to participate in the process as well. And that's consistent with the law of human rights and accommodation, which says that it's a multi-party inquiry. So the employer, the worker, the union, if they're involved, and WorkSafe BC all kind of work together to try to get the worker back. The duty to cooperate is only about communicating, identifying potential suitable work, and then involving the board and sharing all that information together. There's not a duty to actually offer that position as part of the duty to cooperate. That comes later in the duty to accommodate, which I'm going to talk about next. So what if the worker's not cooperating? What if things break down? There is a mechanism to resolve those situations where either party is not complying. There's a provision where the employer or the worker can complain to the board that the other is not cooperating in the process. So if you're trying to reach the worker, that they've hurt their back or something and they're at home, you're trying to reach them, they're not responding, you have some work available and you want to bring them back, but they're not getting in touch with you, you can complain to the board and say, I believe the worker is not complying with this duty. And the board actually has a 60-day mandate to look into it and make a decision. And there's some teeth to this, because if the worker's not cooperating, the board can suspend their benefits or even terminate their benefits. Similarly, if the employer is not cooperating, so the worker's trying to get in touch, the worker wants to come back and believes the employer has some available work for them, the worker can complain to the board as well. And if the employer's offside, they could be hit with a fine. And the maximum amount of the fine is whatever the maximum wage rate is for the given year. So for 2023, the maximum wage rate is $112,800. So almost $115,000 you could be fined if you're going offside of this provision. So very important to pay attention to it, very important to get in touch with the worker, pay attention to the worker, they're trying to get in touch with you. And I think in principle, this dispute resolution is good and allows the board to intervene and get involved and make a quick decision. That being said, it could be abused by either side, particularly if employees, if it's a adversarial situation about the injury, or it's tangled in with some other type of workplace dispute, the worker could be just lodging these complaints against the employer, forcing them to defend themselves. And I think, having to defend themselves to avoid the potential of getting one of these fines. So that's essentially the duty to cooperate. The second part of this is the duty to maintain employment. And I've called it the duty to accommodate because it's essentially, that's essentially what it is. And you're probably thinking, well, I've heard of the duty to accommodate. That's, I already am subject to that duty because of human rights law, right? If someone's injured, that's disability is a protected ground under the Human Rights Code, and I have an obligation to do my best to accommodate them. And if I don't, it could be discriminatory, it could be a breach of the BC Human Rights Code, and they could complain to the BC Human Rights Tribunal. That's true. And the duty to accommodate applies if the injury is work-related, right? It doesn't matter how the injury occurred. It could be something that happened outside of work, could be something that happened during work. If a person's disabled, the employer has a duty to accommodate them. So people are asking, why would we create another duty to accommodate within the Workers' Compensation Act if it already exists under human rights law? And that's a great question. That was one of the criticisms of the Patterson Review, which said there needs to be a duty to accommodate stated explicitly within the Workers' Compensation Act. So that's what was recommended, and that's what's been accepted. So now employers have kind of a double duty to accommodate, one under human rights law, one under WorkSafe BC law, and they could well end up having different definitions, and the consequences to breaching them are separate. So you could be facing one consequence from WorkSafe and then another consequence from the Human Rights Tribunal. So it could get very confusing for employers. And, at this time, we don't really have much guidance in what WorkSafe BC's version of the duty is going to look like. And we'll be watching carefully about how this fleshes out, what kind of policies are put out by the board, and how much of the human rights case law and principles, which has been developed over many, many years and which is very well established, is going to apply to the workers' compensation system. Very important. The first thing to know is whether the duty actually applies to your business and whether it applies to your worker in question. So the legislation says that the duty only applies to employers who regularly employ 20 or more workers. A recent survey from WorkSafe noted that of the 250,000 employers in BC, only 10% of them have 20 or more workers. So the small to mid-sized business is purposely excluded from this section, probably because it's too onerous for a small business to have these double duties, to be subject to fines if they don't comply with the WorkSafe duty. It's too hard to accommodate in that situation. So what does regularly employ mean? Again, we don't have guidance on that. If you are a seasonal business and you're employing, 40 people for 3 months of the year and then 5 people for 9 months of the year, does that mean you're part of this? We don't know. There's probably going to be a policy that comes out which will help us understand that, but ultimately that may be something that gets disputed and there has to be a legal decision about it. If your workforce teeters on that threshold number, so if you go from 18 to 22 over the course of any given year, again, hard to say if you're included, but I would assume you're included, right? If you're having 20 employees employed for any length of time in the course of a year, I would assume you're included, and be prepared to follow this duty to maintain employment and duty to accommodate. The other thing to look at is it doesn't apply to all your workers. So it only applies if the worker has been with you for 12 months or more at the time of the injury. So you want to keep careful records of hire dates. And when you do have an injury, a workplace injury, you want to diarize that in your system to see, has this person been with me for 12 months such that this duty to accommodate and maintain employment applies. So what is the duty? Basically, it comes into play when you've got a worker that's gone off on a claim, they've been disabled for a period of time, they've done some rehab, some treatment, and then they're cleared to return to work in some capacity. So there's two situations. If the worker is fit to work in some way, but they can't go back to the pre-injury job. So that's scenario one. They're fit to come back in some capacity, but not back to the same job because of the injury. In this scenario, the employer must offer the worker the first suitable work that becomes available. So you've got a worker in the warehouse, they have a back injury, they do some rehab, they come back and WorkSafe and their doctor says they can't lift boxes over 20 pounds, but they can do some light duty work. So in that situation, for the employers that this applies to, there's now a positive legal obligation to offer that worker the first available suitable work. So what is suitable work, right? What is work that's available? Those are interesting questions. Again, we don't know what they mean yet. There'll, again, probably be a policy about them. And we can look to existing board policies where suitable work and suitable occupation has been addressed in other contexts, such as when vocational rehab applies and when pensions apply. So a suitable occupation, WorkSafe BC has said, well, that's one that the worker has the necessary skills for, the education and the functional abilities to do. It's one that doesn't impede their health and safety, one that doesn't impede the health and safety of other workers. Suitable work is one that maximizes their long-term earnings potential and is reasonably available to them over the long term. So, you know, in the situation of the warehouse worker, it's unlikely that you're going to have to give them an office job if they don't have any training in office and administration work. It's unlikely that you're going to have to put them into a sales position if they have no skills and experience in sales. You know, you're really just looking at what's actually suitable for this particular worker, given their individual circumstances, given their medical limitations, and then what do we actually have available at the workplace, right? So I think, you know, it's not as onerous as you might think. There's going to be kind of a reasonableness to the whole thing, that you don't have to be going out there and creating new positions for people just to fulfill this obligation. You don't need to be putting people in jobs that they're not suitable for in order to avoid getting fined for not complying with this duty. The second situation is where the worker is fully cleared to come back to work. So, you know, they've gone off, they've done some rehab, they come back fully cleared to go back to that warehouse position. So in that situation, you've got to either give them the same job back that they had when they were injured, or a comparable job that pays the same, or, you know, that effectively is similar, right? Basically, when the person's ready to come back to work, you have to give them their job back, or you have to give them a comparable job. And I think this development is quite significant because under the existing WorkSafe process, there's a 5-phase vocational rehabilitation process, and the board's current policy is just to encourage the employer to you know, accommodate the worker and take them back. They don't actually have the power to force or require the employer to do that. Right now, if you have an injured worker and, you know, WorkSafe BC says they're ready to come back to work, you could tell them theoretically that, sorry, there's just no job available anymore, and WorkSafe will just say, okay, you know, that's fine, and they will go into the next phase of the voc rehab process, which is to help the worker find a job somewhere else or retrain them into another industry. So with this new duty, WorkSafe is now going to have the power to fine you up to $115,000 if you had suitable work you could have accommodated, but you didn't. The way it exists now, if you could have accommodated and you don't, you could face a human rights complaint, right? Because that duty to accommodate still applies in our human rights code. But now with these new changes, you could face both the human rights complaint and the WorkSafe BC fine. So the next slide talks about what are the limits of this duty, and I talked about this a bit already. the limit of accommodating a worker coming back is this idea of undue hardship. So you don't have to go past the point of undue hardship to be able to bring someone back. And undue hardship is a well-known concept under human rights law. The Supreme Court of Canada, which is the highest court, has made a number of statements saying that it doesn't have to be impossible for it to be an undue hardship, but some hardship is acceptable, right? So you may have to rearrange some schedules. You may have to kind of create a hybrid type position, and you have to look at the entire circumstance. So factors like financial cost, disruption of a collective agreement, employee morale, interchangeability of the workforce and facilities, the size of the employer, and safety. Those are all relevant factors in assessing, okay, what's going to be an undue hardship in trying to bring someone back. So it'll be interesting to see if those concepts are just imported into WorkSafe BC law when they examine this undue hardship, or whether there's going to be some new principles. Some important points regarding the duty. It does have an end date. So the duty to maintain employment only exists for a period of 2 years. If your worker goes off and they've been totally disabled for 2 years or more, your duty to maintain employment and accommodate them comes to an end. And this kind of ties with this concept of frustration of contract. So under employment law, if someone is off work for long enough and there's no reasonable prospect of them coming back, you can eventually take the position that their employment has been frustrated. They can no longer do the thing they've been hired to do. There's no reasonable prospect of that ever happening. And therefore, the employment comes to an end by the operation of law. Similarly, if someone is off for 2 years, this duty to accommodate ends, and there's no longer an obligation to offer them suitable work. One thing that's important with that is the date of the injury, right? Because if it's 2 years from the date of injury, the actual date of injury becomes very important. Sometimes it's obvious when the date of injury was, they fell down and injured themselves. It's clear, everyone saw it, we know when it happened. In other cases, like an occupational disease, a mental health issue that arises from, multiple incidents, when do you actually peg the date of the injury? We don't know how that's going to look, but in other cases, WorkSafe BC has said, well, let's look at the actual date of total disability as the date of the injury. So the date they first go off work, right? That's going to be the date we're going to use to start the 2-year clock. Another important thing to note is if someone goes on a WorkSafe BC claim and they come back to work and into an accommodated position or back to their old position, if you terminate their employment, if you dismiss them within 6 months of them coming back, then WorkSafe BC is going to assume that you terminated them because of their WorkSafe BC case. And again, you could be hit with a fine for doing that, and the employee could be paid up to 1 year's wages by WorkSafe if you do that, which would go onto your claims costs. So again, it's very important to evaluate, does this apply to you? Does this apply to the worker? And if you bring a worker back after a WorkSafe BC claim, keep them employed for 6 months unless you have a very, very good reason to terminate them, and you can prove that the termination had nothing to do with their WorkSafe BC claim, because they have that kind of window of protection where there's going to be an automatic inference of a connection between the dismissal and the claim. So we talked a bit about penalties already, and it can be up to the maximum wage rate. That's about $113,000 this year. Importantly, the penalty is paid not to the worker, right? It's considered like an occupational health and safety fine. So it goes into the WorkSafe BC accident fund. It goes into the board's coffers, and it doesn't go directly to the employee. But like I said, the board can pay compensation directly to the employee if they're terminated because of the claim within 6 months. But that's a payment from WorkSafe to the employee. As with all decisions from WorkSafe, you, as an employer, have a right to seek a review. So within 90 days of any decision, you can file a review with the review division, and that's the first level of appeal. And then the final level of appeal is WCAT. So if you're hit with a fine, or if you're hit with a decision that you've breached the duty to maintain someone's employment or the duty to accommodate them, you can appeal that. And that's a lot of the stuff that we do at KSW is helping employers with these appeals. And I think there's going to be a lot more appeals because the decisions are potentially very significant for employers. And one thing that is going to be interesting to follow is if WorkSafe BC makes a decision about whether the employer has accommodated the worker, it may be that that decision becomes binding on any future tribunal or court that considers that same question. So if WorkSafe BC says you fail to accommodate, you may be stuck with that ruling. If the employee then files a human rights complaint, the Human Rights Tribunal may be bound to follow the decision of WorkSafe. And so getting these decisions right when WorkSafe makes them becomes all the more important because of the implications of subsequent proceedings. So that's essentially the summary. Some takeaways, I think employers now have a lot more skin in the game when it comes to WorkSafe claims because of all these major changes. So pay attention at the beginning to know, can you knock the claim out as being not work-related at the beginning and avoid having to deal with all these disputes in the future. Get to know the workers' compensation system so you can make those evaluations. There's a lot of great resources out there, the Employers Advisors Office, the Employers Forum, your legal professionals, consultants, lots of information out there about WorkSafe BC and how the system works. With respect to that duty to cooperate, communication is key. So you have a right to engage with the worker immediately following the injury, where you otherwise might have thought, no, I can't talk to them because they're on a WorkSafe leave. Keep good records. So, the dates of hiring, the date of the injury, the date of the worker coming back, how many workers you regularly employ. Has it been 2 years since the injury? Has it been 6 months since the worker came back? All that stuff needs to be tracked in your diarization system so you know what your obligations are and you can avoid those heavy fines. And then familiarize yourself with human rights law, right? So be mindful of the duty to accommodate, what that means, this concept of undue hardship, how hard do I have to work to accommodate someone? Get to know those principles because they're very well established. And then finally, keep an eye on communications from your sources like the Surrey Board of Trade and your legal professionals on when these duties actually come into force. So we're thinking 2024, but we don't know. So we'd be happy to add any of the members here to our employment and labor newsletter. And that's the kind of stuff that we let people know about on a regular basis. Yeah, so thanks everyone. That is it for the presentation part. We can go to some questions now. Someone has asked, can we get a copy of the slides? Absolutely, we will send those out after the presentation. And yeah, we can open it up for any questions. I don't see any that have come in over the course of the presentation here, but if anyone has a question, feel free to put it into the chat. I don't think we have any questions. So yeah, if anything comes up, feel free to add us to LinkedIn, email us. We're happy to put you on our newsletter, and we'll continue to keep everyone updated and the Surrey Board of Trade updated with these very interesting developments.
Okay, so thank you, Chris and Alejandra, for being with us today and sharing your insights. We will be sending you the recording and the facilitator's contact information after this session. Many more of these type of sessions are coming up, so please check our website at businessinsurrey.com. Make it a great business day and you may leave the meeting. Thank you.